Hi everyone, good morning or good afternoon or good night depending on where you are situated. I'm Álvaro Santos, professor at Georgetown Law and also the faculty director of CAROLA, the Center for the Advancement of the Rule of Law in the Americas. I'm delighted to welcome you all to the first webinar of the CAROLA Fall Series called The Americas in Times of COVID-19. The series consists of 5 modules addressing timely topics, including international investment law, international trade, labor, immigration, and business and human rights. We start today with the first module on international investment law. The kickoff of this series is this first webinar called Shaping Investor-State Arbitration in a COVID-19 World. And I want to first thank our speakers for joining us today. We're delighted to welcome such a superb group of panelists. And I'll introduce them in a second in the order that they will speak. First, let me just tell you, as you know, these are testing times, and part of what we wanted to do with you today is to think about how the measures that states are taking to combat the COVID-19 pandemic, whether they are health measures or economic stimulus measures, are faring, and in what ways can states respond to the possibility of claims by foreign investors. And so what we've asked our speakers to reflect on, given their incredible trajectory and their different fields of expertise and experience, is to share their views about what is the moment that we're on, how does it bode for possible reforms, and how can states deal with the current situation given the emergency that has basically affected all countries in the world. And so we're really pleased and honored to have this group of speakers. Let me start with introducing our first speaker, Minister María Fernanda Espinosa, who is an academic, diplomat, and politician with more than 30 years of professional experience. She's an expert in international affairs and the United Nations, peace and security, sustainable development, climate change, gender equality, and indigenous people's rights. She has a vast experience in intergovernmental negotiations and is recognized as a champion of multilateralism and women's rights and empowerment. She served as Minister of Foreign Affairs, Minister of Defense, Minister of Cultural and Natural Heritage of Ecuador, and was the first female ambassador and permanent representative of Ecuador to the United Nations in New York and Geneva. Most recently, she served as president of the 73rd session of the United Nations General Assembly, becoming the 4th woman in history and the first from Latin America and the Caribbean to preside over this body since its foundation 75 years ago. Next, we will have Matt Potterfield, who is the Deputy Director and Adjunct Professor at the Harrison Institute for Public Law at Georgetown University Law Center. Matt works on various aspects of international economic law, with a particular focus on the relationship between international trade and investment rules and environmental policy. His publications include Rethinking International Investment Governance, Principles for the 21st Century, Assessing the Climate Impact of US Trade Agreements, and Exhaustion of Local Remedies in Investor-State Dispute Settlement, an idea whose time has come, just to name a few. We then have Brooke Guven, who is a senior legal researcher at the Columbia Center on Sustainable Investment. Her work focuses on analyzing the contracts, domestic frameworks, and international legal arrangements governing cross-border investments. In particular, Brooks' work considers the ways in which legal and policy frameworks impact behaviors and how they can and should be shaped to impact sustainable development objectives. Prior to joining CCSI, she was a finance lawyer specializing in cross-border transactions at an international law firm, and also worked as a legal advisor with the Liberian Ministry of Health and Social Welfare. Then we have Lisa Johnson, who leads the Columbia Center on Sustainable Investments work on investment law and policy. Her work centers on analyzing the contractual, legislative, and international legal frameworks governing international investment and shaping the impact that those investments have on sustainable development objectives. She focuses in particular on analyzing international investment treaties and the investor-state arbitrations that arise under them, examining the implications those treaties and cases have for host countries' domestic policies and development strategies. In addition, she concentrates on key institutional and procedural aspects of the legal framework, including efforts to increase transparency and legitimacy of investor-state dispute settlement. And last but not least, we have Nathalie Bernasconi-Osterwalder, who is a senior international lawyer, executive director of the International Institute on Sustainable Development Europe, and is also in charge of the Economic Law and Policy Program at ISD. Mrs. Bernasconi has extensive legal, policy, and training experience in the area of international trade, investment, sustainable development, human rights, international environmental law, and arbitration. She has published widely on the issues, and previously Mrs. Bernasconi worked as an attorney at the Center of International Environmental Law in Washington and Geneva, where she also managed that office. As a fellow at the Institute of International Economic Law at Georgetown University, she worked closely and published with Professors John Jackson and Edith Brown-Weiss. For several years, Mrs. Bernasconi also worked in Hanoi, Vietnam, for a legal reform project of the United Nations Development Program and for the Australian law firm Phillips Fox. In Switzerland, she submitted to the Bar of Basel and was a lawyer at the Swiss Department of Justice in Bern in the section for international law. So, as you can see, we're really lucky to have this incredible lineup. I want to remind the audience that we will have a first part of the session where each of the speakers will make remarks for about 10 minutes. I will be the moderator and keep the time. And after they've all had an opportunity to speak, we'll open up the floor for your questions. So I encourage you to use the Q&A button of the Zoom window where you'll be able to raise questions. You can indicate if the question is directed to someone specifically, or if it's a general question, and I'll basically collect the questions and share them with the speakers to start the second part of our webinar. So without further ado, Minister Espinosa, you have the floor. Thank you very much.
Thank you very, very much indeed, Alvaro, for bringing us together. I would like to start, of course, by thanking the Center for the Advancement of the Rule of Law in the Americas, CAROLA, and you, Alvaro, for this extraordinary Fall 2020 series and for today's theme on shaping investor-state arbitration in a COVID-19 world. I think, it is really a timely dialogue, the need to rethink the international investment law regime, particularly in light of the sanitary and economic measures that states have taken and still have to take to address the COVID-19 pandemic. And I'm truly honored and humbled to share this panel today with such distinguished lawyers with great knowledge and expertise on international arbitration, on foreign investment, and investor-state dispute settlement. And in my contribution, of course, today is not as an expert. I'm not a lawyer, of course, but perhaps I would say more as a citizen that that cares about people, you know, about vulnerable countries and communities and the survival of our planet. And I think that we were discussing just before the opening of this webinar, and COVID-19, unfortunately, is not over yet. We are living it as we speak. So, and I think that every scientist, analyst coincides that we are experiencing the most profound multidimensional economic and social crisis since the Great Depression. So, I think that this pandemic has shown us how frail, but also how interconnected we are as humans. And in spite of all the science, the sophistication of new technologies during the last decades, I think we are facing an unprecedented humanitarian crisis because of a microscopic virus. And I think that it's difficult even, you know, to understand the world as it is now. I think you know the numbers, we all know, but the global recession is projected to cause 5% decrease in global GDP only in 2020. And sadly, here I would like to also highlight Latin America and the Caribbean will be amongst the most affected with a decrease in 9.4% in its GDP. It's a huge, huge setback on sustainable growth in Latin American and Caribbean economies. If we look at poverty, the poverty indicators, 71 million people will be pushed into extreme poverty, and 130 million will be into chronic hunger by the end of 2020. So I think that what we are going to see, and I think that my task here was to set the scene a little bit for the conversation. You know, we can see a setback of up to 25 years in efforts to fight extreme poverty and hunger globally, if, of course, immediate actions are not taken. I'm a stubborn optimist. I think that we can always do something to reverse that trend. If you look at the unemployment rates, they're staggering. 100 million workers into unemployment and underemployment and working poverty, especially youth, young workers. Thus, you know, 1 in 6 young persons stopped working already since the onset of the lockdown because of COVID. And 41 million people will be unemployed in Latin America and the Caribbean, 30 million more compared to last year, to 2019. So, you know, the landscape is not very promising, but we are seeing, you know, some sparks of light here and there. If you look at LDCs, least developed countries, small island developing states, etc., middle income countries like the majority of Latin American countries, you know, in countries that are in conflict, in vulnerable situations, I think that they are suffering the most due to the fragility of their health systems, their limited coverage of their social protection systems, the limited financial resources, the high debt servicing costs, vulnerability to external shocks, and excessive dependence on international trade. And I think all this is relevant for our conversation today. Of course, I think that if we look at the response capacity of the world, I think it's worth you know, highlighting the decision of the G20 countries here that have agreed to suspend the debt service payments for the least developed countries. And we are speaking here about $20 billion until the end of the year. I think, and this decision was important because it was also echoed by a group of hundreds of private creditors as well. I think that this decision is allowing already least developed countries to relocate their budgets on immediate public health investments to fight the COVID-19 pandemic. But the challenge is still huge. I'm always worried about middle-income economies, like 70% of the countries around the world. If we look at recovery packages, we see that over $10 trillion in crisis relief, which is 3 times more than the response of the 2008-2009 financial crisis. And most stimulus packages in the global south and middle income countries are really stopping short. I mean, we are seeing different capacities to respond, and this scenario is really, again, not very promising. And what we see now, and I interact I'm part of the Lancet commissions and other international think tanks, but what we see is that it is urgent that states, governments have the necessary policy space to ensure that basic services are covered, especially now, and that access to health, to water, sanitation, housing, food, and schools are guaranteed. And the only way to do that is through public investment. So and what we are seeing is at the same time, with this need of a policy space, of taking certain decisions, we are seeing this bringing to the light, to the surface, inequalities, injustice, and the human rights and nature's rights crisis, but also more visible, visibly perhaps, people are asking, crying for leadership and global leadership, and talking about poor governance and the need to establish multilateral settings for concerted action. And of course, there the United Nations has an incredible, very important role to play. So I think that this multidimensional crisis amid, this global impetus of promoting public investment, the discussion on the current international investment legal scaffold and the ISDS is of enormous importance. I think that ISDS, and you know very well because you are the experts, have been under scrutiny by both developing and developed countries in the past years. And the key question that I see is whether the current arbitration system allows countries, particularly developing countries, the necessary policy space to guarantee their right to development, the well-being of their people, the fight against inequalities and poverty, especially in these extraordinary times of the COVID-19 pandemic. My belief, and again, I emphasize my non-lawyer condition, is that we are in need of a systemic reform and that would safeguard the sovereign right of states to regulate and balance the rights and responsibilities of investors. And this can only happen if we rethink bilateral investment treaties. And I would go on to further to say that we need to assess the role of foreign investment in sustainable development and the achievement of the sustainable development goals. I think that experiences of developing countries reveal that without such systemic reform, developing countries' ability to use foreign direct investment to guarantee, for example, decent jobs, sustainable development, to meet their climate mitigation targets and commitments will be seriously impaired. So I think that the liberation of ISDS reform ought to be part of a broader holistic approach to reforming substantive and procedural commitments under international investment agreements. So decisions over dispute settlement mechanisms are therefore require, I would say, substantive reform of the international investment regime as a whole. We have witnessed time and again the staggering evidence of the dysfunctions of the current ISDS. Issues of transparency and accountability of arbitration, courts, lawyers are of extreme concern. Conflicts of interest, investor biases, lack of clarity on jurisdiction and boundaries on domestic law, and just to name a few. And I don't have the time here, Alvaro, you would let me know when I have 2 more minutes just to close, but I would like to perhaps bring quickly the 2013 Ecuadorian government establishment of this international commission of experts for a comprehensive audit of investment protection treaties and of the international arbitration system. It was called the CAITISA Commission. And basically the findings there, I think, were very important. The Commission's report in 2017 recommended basically to rethink the country's bilateral investment treaties. And just so we have an idea, is that Ecuador had the highest number of bilateral investment treaties than many other countries in the region, but only received 0.7 of global foreign direct investment that flowed to Latin America and the Caribbean. The main sources of foreign direct investment flows into Ecuador were from, for example, Brazil, Mexico, Panama, none of which have bilateral investment treaties with Ecuador. So of the 7 largest foreign investors in Ecuador, only 23% came from countries with bilateral investment treaties signed with the country. And the case of Ecuador has been 2 minutes, incredible. 26 cases in international tribunals, 15 cases made judgments on jurisdictions, investor had been favored in 13 cases. 87% of the cases were, favoring investors and not, of course, the state. And here we are speaking about more than $22 billion as compensation from Ecuador by corporations. And of course, this doesn't help, the development of a country like Ecuador. And I think it's known, especially by this community, that last April, Jeffrey Sachs, myself, and many concerned citizens signed a request for an immediate moratorium on all arbitration claims by private corporations against government using these international investment treaties. And these considering, the needs for governments to address and respond to the COVID pandemic and its effects. And I think that for the people connected to the webinar, calling, to sign and sponsor this call for a moratorium that is of utmost importance for countries to have the resources to respond to the current multidimensional crisis. I think that just to close, Alvaro, there is hope. I think that the landscape is not very promising, but there is hope. And I would like to mention 2 very relevant ongoing processes that, in my opinion, are going to steer the reshaping of international governance. The number 1 is the Global Pact of the Environment, which is still in a very initial phase, and yet it is a very promising process to set up clear principles and standards on the relationship between the economy and nature, the economy and the environment from a systemic perspective. And the number 2 very promising process is the International Treaty on Transnational Corporations and Human Rights, which I had the privilege to chair when I was ambassador to the UN in Geneva. This international treaty can be a game changer in international investment law and the dispute settlement architecture. 5 negotiation rounds have already taken place. There are some areas of consensus, such as due diligence and protection of victims, which is already a lot, looking at, of course, under the framework of human rights law. And of course, the agreement becomes slimmer when it comes to responsibilities of enterprises, but the negotiations still ongoing. I have great hope for this treaty to go forward. And really, to close, I think that there is a minted phrase, the building back better, and that is our task again. So we have now and today the opportunity of building back better, a more democratic, people-centered international order. In that international order, of course, this new foundational moment for global governance and the voice and agency of citizens, of academia, of civil society, it is telling us we need a more inclusive, efficient, relevant, accountable, and truly multilateral system connected to people's needs and expectations. And that, of course, needs to include new international economic, financial, and trade governance arrangements, and of course, ISDS. So thank you, Alvaro. I would close by that. I think I just stole a few minutes, and back to you, and thank you again for this opportunity.
Thank you so much, Minister Espinosa, for your very valuable insights. You're very modest. You're not a lawyer, but you've held very high public offices as a public official and have this incredible perspective that it's definitely very important for lawyers, economists, and anyone who's interested in this field. So thanks so much for sharing your insights with us. And now I'll turn to Matt Potterfield next. You're on, Matt.
Yep. Okay, I'm trying to share my screen now. Is that working? Alvaro, can you see my screen?
Yes, I can see it, Matt. It's working well.
Great. Well, thank you. There have been a number of different proposals for how governments could mitigate the risk of investor state claims based upon their responses to the pandemic. And I thought it would be helpful to organize them according to two principles. Let's see, there we go. First of all, the stage at which these tactics could be implemented in the arbitration process, whether that be before claims are brought, during the course of the arbitration, or post-award at the recognition and enforcement stage. And second, whether or not these are approaches that could be implemented unilaterally by governments or whether they would require some degree of international coordination. So starting with the pre-claim stage, most investment treaties now can be terminated unilaterally, given that they have run through their initial term, and countries can terminate them with appropriate notice, subject, of course, to any applicable survival clauses. There are also grounds for termination or suspension of investment treaties based upon international law, including most obviously rebus sic stantibus, the doctrine of fundamental changes, which can be a basis for terminating or suspending a treaty unilaterally under the Vienna Convention if there is a fundamental change of circumstances that significantly alters the obligations under a treaty that the parties could not have reasonably anticipated. Parties could also withdraw consent to arbitration under investment treaties that are still in force. Depending upon the arbitration clause in a particular treaty, that may or may not constitute a violation of the treaty. However, in either instance, it still could prevent an investor from perfecting the consent to arbitration and proceeding with a claim. At the international level, the parties to treaties can, by mutual consent, terminate, suspend, or amend the treaties at any time. There's been some discussion, as those of you who have been following the WG3 process in UNCITRAL, of the potential to use some sort of multilateral instrument to amend the network of investment treaties more efficiently. And in particular, there's been discussion of the potential to use the OECD's multilateral tax instrument, the MLI, or the Mauritius Convention on transparency and investor state dispute settlement as models. And we're working on a framework convention on investment and sustainable development, which provide a vehicle for states to modify their investment treaties in a manner that would give them maximum control over the particular reforms that they wanted to implement. In the course of an arbitration, after a claim has been brought, there's a variety of defenses available under international law. I won't go into too much detail. Some of them are same doctrines that could be invoked as a basis for termination or suspension of an investment treaty. There are also a number of defenses available under the ILC's Articles on State Responsibility, including force majeure, distress, and necessity. And again, even after a claim has been brought, states still could, by mutual agreement, terminate, suspend, or amend their investment treaties. And that arguably would prevent even a claim that had been instituted from proceeding. Now that will certainly be controversial. Investors will inevitably claim that their rights to proceed with their claim have already been perfected, but there really is no clear law on this point. And in general, under international law, states are masters of the treaties to which they are party, and by mutual agreement have the power to terminate them or modify them at any point. And finally, even after there has been an award in an investor-state arbitration, the pandemic may provide a basis for some challenges to attempts to enforce that award. Just as an example, under the New York Convention, it could be argued that enforcing an award based upon a legitimate response to the pandemic would be contrary to public policy. And I think that's a plausible argument that a global pandemic of unprecedented scale in the last 100 years constitutes a significant enough event that there is a strong public policy argument for not enforcing arbitral awards. And potentially there may be a basis for arguing that there is some deficiency in the arbitration agreement that was the basis for the arbitral proceeding and subsequent award. So I'll conclude with just a couple of observations about why I think among all these approaches, there are a number of advantages for states to take action before claims have been brought. So to start, economy. If states take action before claims have been brought, they have the potential to avoid at least some of the claims and the attendant costs, which even just for the litigation expenses, the legal fees can run into the millions of dollars per claim. Also control. The unilateral approaches I outlined at the pre-claim phase can be implemented quickly by states without a need to reach any sort of international agreement. In terms of efficacy, the approaches taken with other treaty parties at the pre-claim stage would probably provide the most robust legal defenses. So if you can get your treaty parties to agree to suspend, amend, or terminate the treaties before claims are brought, then you're in a relatively strong position to avoid claims. And finally, synergy. These approaches in general are not mutually exclusive. And by taking action before claims are brought, states could put themselves in the position where they would be able to assert some of these defenses also at later stages in the proceeding, for instance, by withdrawing consent or by terminating a treaty. They would cause a defect in the arbitration agreement that would be the basis for any subsequent award. And that would likely be a basis for a defense to enforcement under the New York Convention. And with that, I will turn my screen back over to Alvaro.
Thank you, Matt. And so next we're going to turn to Lisa Johnson from the Colombian Center on Sustainable Investment.
Great, thank you so much. I'm going to start my timer, make sure I don't run over. Thank you so much again for the invitation to be here. It's great to be able to talk about this work and to share the virtual floor with everyone. I am going to talk a little bit about some work that my colleagues and I have been doing at CCSI. Brooke is also on the webinar together with Lisa Sachs, who's not on, and Jesse Coleman, who's not on. And a lot of it is enshrined in the submission that we made to UNCITRAL with IISD and IIED. So Nathalie, if you have anything to add, obviously do that when it's your turn as well. So last year, we made a submission to UNCITRAL that was motivated by a few things that I think are exacerbated now with the current COVID crisis. So our submission is on, it tries to implement a lot of the things that Matt was just talking about in terms of how bilaterally or multilaterally you can address existing treaties, address ISDS under existing treaties. So what motivated our submission was that there had been agreement within UNCITRAL that ISDS was fundamentally flawed. Oops. Okay, you got a Brooke. Sorry, Brooke, you're doing the slide. So there's agreement within UNCITRAL, which is the United Nations Commission on International Trade Law. It's currently undergoing the process of working on ISDS reform. And they agreed, the states there, that ISDS is fundamentally flawed and is in need of systemic reform. And the issues identified range to kind of a lack of guarantees of independence and independence and impartiality of adjudicators, concerns around the consistency, the predictability, the correctness of outcomes. There's a number of kind of really core concerns about the system. So they agreed to work on reform, but the timeline of that reform is very uncertain. So we were thinking that it might take something like 10 years, and recent documents prepared by the UNCITRAL Secretariat show that that is indeed kind of a reasonable timeline of when they might have an outcome from this process. And then once they have an outcome, there are questions about its effectiveness. How many state parties will sign on to this new instrument, will adopt this new instrument? Will the capital exporting states that are the key sources of claims, will they actually sign on to this instrument? Will investors be able to treaty shop around this new instrument or instruments? So I think there are a lot of concerns about the kind of the effectiveness and the timing of any reforms. So we thought it was important to do something in the near term to address the risk of ISDS, and it would require also kind of a good faith commitment on behalf of the capital exporting states that were participating in the UNCITRAL process. You have the EU and European member states saying we need a court because the system is so fundamentally broken that we can't continue on with ISDS as is. So if we need a court, what can we do in the meantime to make sure that states don't continue to be subject to these disputes? So next slide, Brooke. So the two things that we advance in this proposal, in the submission to UNCITRAL, the two mechanisms are an agreement on withdrawal of consent to arbitrate, and also an agreement to terminate multilaterally terminate your investment treaty. So I'll talk about the withdrawal of consent, and then Brooke on the termination. So the theory, as Matt was explaining, the theory on the withdrawal of consent is that in treaties, states provide this open offer of consent to arbitrate disputes. Not all treaties are written the same, not all express that as clearly, not all states might have intended that, but that is generally the theory, that you provide this advance offer to arbitrate that then is perfected when the investor accepts it. And before the investor accepts it, the state can then withdraw that offer. So if that offer is withdrawn, investors can't perfect it, there is no arbitration agreement under which tribunals can take jurisdiction. If a tribunal does accept jurisdiction, then as Matt explained, states can potentially do things at the set aside phase to then set aside the award, or can use under the ICSID process, maybe annulling the award. Next slide. So in practice, the way it would work is the state A says to state B, I withdraw my offer of consent. State B either says, I agree, I want to do that too, or I agree, I'll let you do that. Or it says, I don't agree, that's a violation of the treaty. Under either scenario, if an investor brings a claim, a tribunal, there is the risk that the tribunal will still, in fact, take jurisdiction. But it makes the claim riskier. It makes jurisdiction less certain, and it makes challenges to the award also more likely. So when an investor is thinking about whether or not to bring a claim, it changes that cost-benefit analysis. Okay, go one more slide, Brooke. So what the proposal does is it provides a mechanism whereby states can kind of unilaterally sign on to this multilateral instrument to indicate that they want to withdraw consent to ISDS. I'm going to move kind of quickly through these. So maybe next slide, Brooke. So a point that I want to make is that, and we tried to make in the submission as well, is that once you withdraw consent to arbitrate, you still leave in place the treaty. you still leave in place state-to-state dispute settlement mechanisms. We're not saying that we want to leave investors without remedies or without protections. We're leaving them with a treaty, we're leaving them with a state-to-state dispute settlement mechanism, and we're still leaving states the ability to agree on a case-by-case basis whether or not they want to arbitrate that dispute. So in terms of COVID, I think that it makes the rationale for this type of approach, this time-sensitive approach, even more relevant, right? That the reasons why you might want to take this action are even more compelling in doing this in a timely way. So, and you can also adjust the mechanism to be able to address it in a COVID specific way. So you can agree to arbitrate non-COVID related claims, for instance. You can list or delist treaties over time as the COVID pandemic might subside and economic recovery speeds up as we hope it will. So maybe next slide, Brooke. Okay, and then I'll turn it over to Brooke to continue on termination.
Okay, thanks, Lisa. So the other option that the submission we made with IED and ISD sets forth is language, specific treaty language that could be used to terminate investment treaties. So there are, again, two options, which Matt set forth at the beginning very helpfully, unilateral termination or bi or multilateral termination. So unilaterally, states can terminate treaties in accordance with the treaty terms or in accordance with other provisions of the Vienna Convention. So in accordance with the terms would usually be, the treaty is in effect for 10 years and then either state can notify the other treaty party that it's terminating or no longer wants that treaty in effect. So the treaty would then expire. In that instance, in accordance with the terms, the survival clause is likely to remain intact. I don't know of any treaty that doesn't include a survival clause that would terminate in that way. But then there are some other Vienna Convention possibilities where the survival clause may not. So states have taken unilateral action to terminate treaties, South Africa, Ecuador, Indonesia, a few others. And outside of the investment law sphere, this is not at all a radical idea. Okay, next slide. So then the bi or multilateral option. So to the extent states agree by subsequent agreement to terminate their treaties, they have a wider range of flexibility as to the ways in which they would want to terminate their treaties. So for example, flexibility to waive notice periods, and very, very importantly, particularly in the context of COVID, they would have the flexibility to take out and remove that survival clause. So that clause that otherwise says the treaty protections are in force for another 10, 15, 20 years could be eliminated immediately prior or consecutively with the termination, which would then allow states to completely end all of those obligations in the COVID context. So interestingly enough, the European Union countries have recently entered into a multilateral agreement to terminate all intra-EU BITs. That was related to some EU legal issues, which many of you are certainly aware of. But that treaty also makes very clear that the survival clause is no longer in effect due to some nuances of EU law, but you could also do that with any multilateral treaty. So if treaties are terminated, again, Lisa ran through this, but I want to reemphasize, investors still retain domestic legal rights. They still retain contract-based legal rights, which in the investor-state contract case often includes international arbitration or contract-based international arbitration. There's political risk insurance, which many investors rely on. There are human rights law, other areas of international law, sort of customary international law, legal protections afforded to aliens that do still protect foreign investors who are investing into company or into host states. So to the extent you're terminating these treaties, investors are certainly not left without remedy. So there are obviously considerations that states will wish to go through when thinking about their legal options. And Nathalie, I think, or during the discussion, we can talk about, sort of the political challenges that states may have in affecting these outcomes. But it is, I think, absolutely clear at this point and a very strong consideration for states that these claims are going to come. It is really only a question of timing and potentially of scale. But they are absolutely going to come. And so states really should be thinking now about how they want to approach this and what the costs and benefits are of their different options. So the most solid position that Matt laid out is mutual agreement to try to eliminate or limit these claims in advance before they are initiated. So There are various ways states could do that, through a treaty-based mutual agreement or through these multilateral processes, such as UNCITRAL's Working Group 3 on ISDS reform that's currently ongoing. Thus far, we haven't seen a willingness for Working Group 3 to take on the task of a multilateral negotiation on how to manage and deal with COVID claims. Perhaps there are other multilateral fora that may be willing to take this on in a more robust fashion. But outside of those options, if mutual agreement can't be achieved, it's important for states to really do this cost-benefit analysis. Do they want to stay in the treaty as it is? Do they want to look at unilateral termination, which may include the survival clause? Do they want to try to withdraw consent? So there are strong reasons for unilateral action, even if states cannot get multilateral action. And Matt set out some of them earlier, but I want to reemphasize this may be the only option, but that doesn't mean it has no effects. So skipping slightly, but also we did want to emphasize that terminating treaties has not been demonstrated to evidence a decrease in overall FDI or investment flows. So, you know, that fear of terminating treaties perhaps is not demonstrated in reality as impacting investment. But one issue, and Matt raised the issue of effectiveness, and I think we spoke about, you know, sort of challenging the jurisdiction in the annulment proceeding or in set aside. There's also this issue of third-party funding, and I just want to highlight it here. It's something else that is the subject of ISDS reform, and we, along with IED and ISD, have been working a lot on this and have made submissions on this. But third-party funding in COVID claims is likely to play a very big role. And a third-party funder is an investment fund that basically invests in the claim in exchange for an outcome, return in the award. They will be seeking, and we saw this in 2008-2009 recession, higher returns on these investments than they can get elsewhere. And so these litigation ISDS claims offer a really attractive avenue for those kind of high returns. And just the nuances of ISDS, again, make it so attractive for third-party funders. Shareholder claims are unlimited, so there is a choice of different treaties and different ways in which they can bring claims. Third-party funding is currently unregulated, but taking these unilateral actions that would draw into question the state's consent to arbitrate jurisdiction, that could really cause questions among third-party funders as to whether this legal action is really as tied up as they would like to be to invest the millions of dollars that they would have to invest to bring these claims. So I'm going to just turn it over to Lisa quickly to discuss fundamental change of circumstances.
Yeah, just very, very briefly, I just wanted to add something because there is this challenge of unilateral action, and we fear that many states would be in the position where they can't really get their treaty partners to agree to terminate, to agree to amend, to agree to let them withdraw consent. So thinking about what other options are available to states, and it is worthwhile to explore further Article 62 on fundamental change of circumstances under the Vienna Convention on the Law of Treaties for a ground for states to decide to terminate or suspend their treaties. And I think there are some general considerations that apply even outside of the COVID context that might make this doctrine applicable. So for instance, tribunals' approaches to shareholder claims, tribunals' approaches to damages, the nature of the obligations and the way that they've been interpreted over time. The role of the state in effectively managing the treaty might be very different from in practice than the states had envisioned when signing the treaty. The nature of FDI might have changed, and also our understanding of FDI and its impacts. So I think that those are a series of kind of changed circumstances that, depending on the treaty and when it was concluded, could be a ground for a state to take action on termination and suspension. And then COVID, again, raises a whole new set of changed circumstances. As we all know, the word unprecedented is used every time we talk about COVID. We are in a different world. And so thinking about how that might apply to support states in taking action. So with that, I will stop there and turn it over to Nathalie. Thanks.
Thank you very much, Lisa and Brooke. And so, yes, next, Nathalie Bernasconi from the International Institute on Sustainable Development.
Thank you very much. Can you see my screen? I'm just checking.
Yes, we can see your screen fine. It's not in slideshow. Yes, there it is.
Okay, great. I'm just going to check. Okay. So, well, thank you very much, Alvaro, for the invitation, and I'm so happy to be here with friends on this panel. And thanks also to CAROLA Georgetown Law. As you noted, I did my LLM at Georgetown many years ago, so I have a fond recollection of Georgetown University Law Center. So thanks for the invitation. I wanted to follow up on the previous interventions and actually go a little bit into a detailed discussion about a proposal for an agreement to suspend investor-state dispute settlement in relation to COVID-19 related measures, and just give you a bit of background on this idea. And of course, it builds on the work that Lise and also Brooke presented. And it has to be seen as one proposal amongst many that Matt pointed out earlier at the beginning of his presentation when he had the chart that showed all the different sort of actions that could be taken at different phases of the investment, of an investment, and whether it's before a claim is brought, after a claim is brought, etc. But what I wanted to share with you is this proposal for, or this proposed language, which we developed during this, confinement, basically. At least I was at one point stuck for 2 weeks in my room, and really became a little bit obsessed about the idea that there could be so many claims brought against states in COVID times. And then looking at, previous crises and how many claims were brought as a consequence of crises. And what was different here was that everybody was in the same boat. So it wasn't the Argentinian crisis or, North Africa dealing with the revolution at the time, but it was really about a health crisis that everybody was facing. And, all governments were taking drastic actions. I mean, there were differences between the governments, and governments took different actions at different moments, but it was just really what Lise just said, unprecedented. And we, a year ago, none of us would have ever thought about this. And one thing we thought at the time during this confinement is that something has to be done. And what could this be? And of course, there are many different possibilities. And what we thought about, okay, because everybody's in the same boat, is there not an opportunity to get to a consensual solution? I actually totally agree that in many instances, countries really may have to look at unilateral solutions, and unilateral doesn't mean illegal, right? But at this point, we thought, okay, well, this is so huge and everybody's facing the same problem, so wouldn't this be a moment where we can find a joint solution and address at least one ISDS related risk, those under treaties, because of course we also have them under contracts and possibly under some investment laws. And then we looked at the options that Matt already talked about, so I won't go into the details. But of course, you can think this may be a time where you just say, okay, this is too risky, we need to terminate. You could think about amendment, but there the efficacy that also was mentioned by Matt, we thought it could be quite complex to actually start amending a treaty. Joint interpretation brought with it all kinds of questions as well, especially the fact that if you have a joint interpretation, the claim will already have come to a certain stage. So you don't block a claim, you let the claim go ahead, and then the tribunal looks at the interpretation. And it may give you better chances to defend yourself, but everything will still be uncertain, and a country will have to defend itself, possibly at multiple, in front of multiple tribunals. So we ended up thinking, okay, I think in terms of what we have under the Vienna Convention of the Law and Treaties, suspension would be an option. And it's called suspension, but it's also, we've heard if you have a moratorium. We've heard many calls for moratoriums. There's this very important call that the minister referred to as well, for a moratorium of ISDS claims, so that a suspension is really the same thing. It's just the language that is used under the Vienna Convention. And so we decided to just try to develop some language for the agreement, for an agreement for the coordinated suspension of investor-state dispute settlement with respect to COVID-19 related measures and disputes. So we took the text is built on the idea that there would be a multilateral text, but everything could be amended very easily for a bilateral situation. And we got input from, we had consultations with mostly developing countries, but also put it online and got really good and interesting responses from academics and experts, practitioners. And we actually amended, if you saw the different draft text, you would see that we integrated quite a few of the proposals or the proposed amendments. The main provision is really about precisely the suspension of investor-state dispute settlement for COVID-related measures. And we wrote for that, the operation of the provision or provisions of any investment treaty in force between two or more signatories to this agreement, providing for the settlement of disputes between an investor and a state, is hereby suspended, okay? So we could stop here. We could stop here, and then we would have the moratorium, which would be across the board. And that is totally justifiable, and for some countries would be the right way to go ahead. It just might be a little bit more difficult than if you limit it to a suspension in respect of claims that are COVID related. And you'll see here the language actually doesn't added a self-judging element to it, and that actually came out of the consultation, so that we don't just say in respect of measures or COVID-related measures, but we say is hereby suspended in respect of claims that the respondent signatory state considers to concern COVID-related measures. And later on, we still give a definition, but the point here is that during the consultation, experts really convinced us that opening the door to basically a dispute around what is a COVID-related measure, even if you give a pretty good definition, it just opens the door to too much mischief. And so we adopted that proposal in the consultation process. So it's really to protect the state further. But again, here it's only the clauses on ISDS that are targeted. So like Lee said in our submission to UNCITRAL, it's not about everything. So we're leaving for if a state really misuses this treaty, you can still have your home state actually sue the host state and have a state-to-state dispute sorted out at that level. Then we define what is an investment treaty. This is more or less based on the Mauritius Convention definition. And then we had to address the idea or the situation in which not all parties of an investment agreement are signatories to the suspension agreement. So if you have you know, CPTPP, or you have a regional agreement, then this suspension would only apply between those states that have signed the agreement, not to all the CPTPP parties or all that, you know, NAFTA 0.2 parties where ISDS is still applicable. The other issue here is we did originally have a definition of COVID-related measures, and we kept it, even though it's still self-judging, but we have defined COVID-related measures to include, well, the starting point is measures taken after the 1st of December 2019, and that's when we had the first appearance or got to know about the COVID-19 in China. And we added really here too, there was some changes made during the consultation, but the main thrust is that you want to have measures covered, both health measures, but also economic measures. We took the option of if countries wanted to list out certain agreements. So if if it's a multilateral agreement, all the bits between or investment treaties between the signatories would automatically be covered, but to make it maybe a better sell, you could add something where you could list out certain agreements. We think that listing in is not a good idea, so we think it should be a negative list approach. The agreement would come into force upon the signature, and if you had a multilateral agreement, you need some kind of depository. It doesn't have to be at the UN. It could also be, it could be a designated state or a regional organization. That's up to the parties. And then finally, the issue is, okay, if we're suspending, it's until when? Is it permanent? It can be permanent. It's not disallowed, but countries might want to limit it, except that it's very hard. So once the WHO says the pandemic is over, it doesn't necessarily mean that, you still need to take that, after the pandemic, you still have COVID-related measures that a government has to take. And so it would have to, go beyond just the pandemic stage, probably. And since we don't know how long these kinds of claims could still come in, depending on the treaty, you could either set up a process to limit the time, or you limit the time in advance, but it's very hard to know what would be the right date. And so that's it. I mean, I think I went over time, but this is a bit of an overview. It's quite narrow, and some countries might want something broader. You can use it also bilaterally, but the reason we proposed language that's narrow is that we think because everybody's in the same boat, maybe at least a suspension with respect to COVID-related measures would be something that countries could agree on. Thanks.
Thank you so much, Nathalie. And so we're going to begin our Q&A session, and participants will be able to see all of our speakers at the same time. And so I encourage participants, when they write their questions, please just put your affiliation so that we can see where you are. Let me just highlight a couple or a series of themes that came out of this discussion. It seems to me that one of the recurrent ideas is that COVID-19 has presented an important threat to states, but that it comes comes in a context where there were already considerable criticisms and concerns about the international investment law regime, and particularly ISDS. So in some ways, the COVID-19 pandemic has put in high relief some of the structural questions that many of you have been addressing and that had been sort of present in the debates about how to reform the system. Another important theme I think that came out is that as opposed to previous crises where you could identify maybe a potential cause and that this was related to one government's own troubles or mismanagement that gave rise to basically a series of investment claims. What we're seeing now is really a crisis that's affecting all countries at the same time. And so that these might represent a unique opportunity to basically explore what those challenges are, since all states will benefit from reform. And this again is also coming sort of in the tracks of developments we see in the system where traditional capital exporting countries or rich countries have become more concerned of ISDS. This was evident for the case of the US in the USMCA and in TTP, and also for Europe in the case of the TTIP or the trade agreement between Europe and the US. So this is nothing new in some ways, but what we're seeing is that it puts again those concerns in front and center. Also a very important theme on policy space and the need for states to be able to address some of their main concerns regarding investment, how to address investment in a way or use and mobilize investment in a way that could serve their public interest. So in the end, a need to rebalance the interest of investors and the interest of states and their societies. So these are just some of the themes that were, I think, very salient. Of course, what was really, I thought, useful and productive about the way you spoke is that it complemented, the presentations complemented each other also at the technical level, providing a very clear view of the tools that states may have to address the potential threat of investors' claims. And so thank you for these really wonderful and enriching presentations. I see that we have a couple of questions. Let me start with a question to kick off the discussion. And this will be a question to Minister Espinosa. The picture that you provided at the beginning of what COVID-19 is doing and basically the damage that it will present states is pretty bleak. But at the same time, you ended up with a note of optimism about the possibility of states to take basically this up and make some meaningful change. And so given your experience, your unique and exceptional trajectory as a public official, what opportunities do you see here for states to turn this into successful action? That is, how can we think about COVID-19, or in your view, what does it offer for states to make meaningful change or reform at this moment?
Well, thank you, Alvaro, but above all, thank you to all of you, because basically you have provided, in a way, a roadmap with very, very concrete proposals, even with language that, you know, that states can use to rethink, renegotiate their bilateral investment treaties, but just to take a fresh look to the ISDS mechanism. So thank you so much for that. In, you know, what I see, of course, the overall panorama is really worrisome. You know, the COVID is affecting every country every society, but it is affecting more the poor and the most vulnerable countries. So what we are seeing is, in spite of the crisis, also an incredible amount of creativity, an incredible space to rediscuss and redefine. There's so many conversations going on now to rethink global governance as a whole, you know, to rejuvenate the United Nations, to reform here and there. And I think that we have to grab the golden opportunity to rethink global governance. And of course, investment and trade law is, you know, has to be part of the equation. So I think that we are experiencing this like a feeling of a new era, of the opportunity to bring, you know, the brilliant ideas that we have heard. And I think we have to push, for example, in the umbrella of UNCITRAL, to bring in wisdom and knowledge, you know, to advise member states, because we see here a plethora of concrete proposals. But for me, the challenge is to connect, you know, the academia and the science and the knowledge to political decision making. Usually what I see and I feel in my own experiences is this gap, you know. So diplomacy has to come on pleine force, as we say, you know, to make sure that member states can have a hold of, you know, all these very specific, concrete proposals that are actionable, doable in the context of an overall multilateral negotiation. And we heard from Nathalie and from Brooke and Matthew saying it can be done either bilaterally or multilaterally. And of course, countries like South Africa or my own country, Ecuador, we have dealt with the situation, you know, in a bilateral way. But I think it's stronger, more structural to have this multilateral umbrella. And I am really a stubborn optimist. And please, you know, contribute and follow the negotiation of the internationally legally binding instrument on transnational corporations and human rights. It's a great umbrella, and we need you. You know, we need this informed decision-making process, these tools in the hands of member states. And here, as you very well put it, Alvaro, but all of you said, this is not only a developing country concern, it's everybody's concern. So we should grab the opportunity of building back better and just do it and connect with decision makers. And I would stop there because I'm very passionate about that, and I'll stop there. And thank you. Back to you, Alvaro.
Thank you so much. Okay, so we have a question by my colleague Itai Grimberg, who's a professor at Georgetown and an expert in tax law. So he asks, and I think Liz has already identified himself as a respondent, which is great. So he asks, what does it mean to say that investors still have the treaty if they have only state-to-state remedies? And then also, why would unilateral withdrawal to arbitrate seem more attractive to host countries during the COVID than before? Aren't they going to be more concerned about attracting foreign direct investment and not seeming differentially unattractive than they were before? Lisa.
Sure, great. And before I start, I just want to also just flag that, you know, I focused on termination and withdrawal of consent and Nathalie on suspension, but definitely don't want to suggest those options as preferable to suspension. It just hadn't even been on our radar when we were drafting that submission. So really think it's great to look at suspension as well. On the questions, I mean, I think this issue of states' concern about attracting investment is a really important one. It's a real issue to flag. I mean, states, as we know, they're desperate to attract or keep investment in this context. And so they might be particularly unlikely to want to take steps to address their investment treaties now, even though there is this lack of evidence about you know, whether or not treaties even make a difference to investment. decisions. So I think it's really important to focus on two things. One is this multilateral or joint route, and the idea behind that is if you act together, you prevent states for competing for investment through the use of investment treaties. You try and stop them from saying, oh, we've got an investment treaty and that's their tool for attracting investment as compared to another, even though again, the link is far from demonstrated. But we think that joint action will provide comfort to states that they won't actually lose out on investment because other states are doing it too. And then second, I think it's important to normalize this idea that walking away from ISDS is not walking away from investment. It's not being unfriendly to investment. It's really just trying to level the playing field and say this actually doesn't make sense from a cost-benefit perspective. So we want to make sure that this is seen as a considered a rational decision, considered and rational, not considered irrational. I was kind of unclear there, but a considered rational decision. And so something that is not seen as anti-investment. But I agree that is a real concern that states have, and it's even more real now and with COVID and the shortage of money. So, thanks.
Great, thank you, Liz. Let me see if another speaker wants to jump in or follow up on this question. Otherwise, I'll move on to the next one. But if anyone else wants to address this would be a good time. Okay, wonderful. So we have a question from James Carey, who was a student at Georgetown. I think he graduated and also worked at the Harrison Institute. And his question is, does the different timeline of COVID impact around the world, see China versus the US, change what will be covered by COVID-related claims? How can we plan for a future when not everyone is in the same boat and the effects of the virus are at very different stages around the world? So this is let me just offer this to the speakers. Perfect, Nathalie, if you want to give it a shot.
Yeah, I think, the timeline doesn't really matter that much because these claims, under most investment treaties that will be used to bring claims, they don't really have a limit to, most of them don't limit until when you can bring claims. So, even if once the situation settles down in terms of the pandemic and you're well beyond that, measures that were taken before can still be challenged. And we did a little quick study and actually looked at, crises, and in some cases the disputes were brought really quickly, but many were brought much later when, the crisis had already kind of, was at a different phase. And that's why with the suspension agreement, we say that you need to cover measures all the way back from 1st of December. All measures that were taken in response to the COVID pandemic, whether they're health related or economic, should be covered. So it doesn't really matter that much. I think the response, if you do address the problem, you just need to make sure that it's not really retrospective in the sense that the claim still will be brought in the future. But what you're doing is that you're saying, for all these measures, we're suspending the operation of ISDS clauses. And so I think you can do that. And in terms of for the future, that's why I mentioned in the last article of the agreement, either you can make the suspension permanent and then at some point just decide to do something about it and stop it or keep it or whatever in terms of the countries. But countries can also decide to put a process in place so that every 5 years you sit down and say, is this still needed or not? Or you could just say, okay, by, I don't know, 2050, you know, ISDS is suspended until 2050 in relation to COVID-related measures. And maybe after a certain moment, you won't have, you know, the chances are smaller that a claim will be brought. But in theory, you can bring claims, you know, a long time later. But I think you can deal with it if you want to.
So, Nathalie, let me just follow up. There was a question about what do we define as COVID-19 claim, and I think you addressed it in your presentation and also just now. But so, if we think about the scope of the moratorium, basically, as I understand it, it would be covering measures, whether it's health or economic measures, starting at that specific date. But the claims that may arise from measures taken before, and that the states will have to address and tackle and litigate during the pandemic, those would be permitted according to your proposal.
Well, you know, personally, just from a personal perspective, I think a moratorium or suspension across the board is warranted, especially during the pandemic. And I think that the declaration that was referred to earlier, you know, kind of gives another rationale why a suspension is needed. You can, you know, it's a really big burden for governments at this point during the pandemic. So you could even say, okay, during the pandemic, until the WHO declares that the pandemic is over, you could say full suspension of any claim. And then you could say, but you know, after that, it's only COVID related, or there's so many things that you can nuance. The governments are the masters of their treaties or their actions. And so you just need to decide. The reason we put this forward is because it's a bit more complicated. So you can always make it, you just take out that COVID related part and take the suspension agreement. It's much easier. So that's always doable. But we thought, okay, we need to think through for those governments where you can't negotiate, you know, a full suspension, that you have just with respect to COVID related measures. Because my view is, you know, European countries, for example, they're taking drastic measures. So would they want to be sued? No, I don't think so. So they should be interested in you know, protecting their COVID-related measures, but they might not be ready to go further than that. Not saying that's good or bad. I'm just saying, you know, it's kind of it's an assessment. What is doable and what isn't.
Thank you. And let me just point our participants to the letter that Minister Espinosa referred to, calling for a moratorium. It's now available on the Zoom chat, so you can see the link and go to that, and you'll see the statement and the signatories to the moratorium call. Okay, so as I understand it, Nathalie, then this is obviously a really important stopgap to allow countries this breathing room as they figure out what they can do and how they can address these other claims. And in this regard, the work that both Matt and Liz and Brooke have put forward could address more structural questions about how states might deal with these claims in terms of alleging fundamental change of circumstances, as Matt was explaining, or also in withdrawing the anticipated consent to arbitrate or terminating the treaties. And so in some ways, there's a way in which these proposals can be very complementary. Mm-hmm. We have 3 minutes left, and so I want to give a chance to the speakers if they want to share a concluding thought before we close the panel today. And you don't have to, but if you have something that you'd like to leave our audience with, this would be a good time to do that.
I'd just like to briefly pick up on Minister Espinosa's observation about the need to connect the political actors with the lawyers. There does seem to be a disconnect, and I think it's important for policymakers to understand that there are a lot of options. There are many different legal strategies that could be implemented, but there is a need to exercise the political will to make those decisions. And I think that's really been one positive outcome of the UNCITRAL process. It may have been slow so far on some reforms, but the mere process of bringing delegates together from different developing countries in particular, I think has helped to reveal a lot of common interests in implementing some sort of reform agenda. And hopefully that will bear fruit.
Thank you, Matt.
Should I go next?
Yes.
Oh no, Minister Espinosa, why don't you go?
No, you go ahead, please.
I mean, I also wanted to second your remarks. I found it really important what you said about silos and working across them. And I think it's very clear how you're in different spheres and have this broader perspective. And I do think that is what we need in this context, that COVID, it creates so many challenges, but it gives us this opportunity where people can be more creative in terms of thinking about what type of system we need. And we have places where we can talk about it, put this into practice right now. So I hope that we can cross silos and use this opportunity for rethinking and rebuilding to really do it. So really appreciated those remarks.
Thanks, Minister.
Well, I was just going to say, very simple. I think that I have followed closely what Ecuador did with the bilateral investment treaties. I think they said, well, we don't have evidence how much bilateral investment treaties favor, foreign investment and sustainable development at the local level. We have this very tiny contribution, which is the report of the Ecuadorian International Commission, that really shows that there's no direct correlation between, sustainable development, fighting inequality and poverty with bilateral investment treaties. Brazil has never had a bilateral investment treaty, and we have seen, well, not now perhaps, but in the past, a lot of movement in terms of foreign investment. But better, you are the experts. And I was going to say, it's been very hard to go through the go it alone kind of mode. Ecuador, a tiny country in South America, well, South Africa, Indonesia, and we have come together to have a conversation of good practices and the model law that the South Africans were preparing. I have lost track a little bit of that. So the multilateral approach to reform, I think, really allows, to level the playing field, as you were saying, Alvaro, and not to compete with each other, which, not to leave any gaps in between, but to have a multilateral response. I'm a multilateralist by excellence, but these structural changes, these mindset changes should come into play under the umbrella of the multilateral settings. And I agree, UNCITRAL can be seen as, slow pace. Multilateralism sometimes is slow, but it can be efficient because, it provides an outlet, to deal with our global commons. And there's a lot of conversation saying that public health should be considered not only a human right, but a global commons as well. And not to speak about climate or biodiversity, etc. And these issues, have to be discussed internationally with your wisdom, with your contributions. And I was saying, when we were in the process of negotiating these issues bilaterally, we would have benefited so much to have the Alvaros and the Lises and the Nathalies with us helping us to develop the right language, to understand better, the difference between suspension and moratorium, the legal implications, all of that. So we need the tools that you are providing. We need a multilateral approach for a systemic reform, and we need to grab the opportunity of the pain of the COVID, but also of the opportunity of COVID to rethink our international system as a whole. So thank you again. I'll stop there.
Thank you, Minister Espinosa. Nathalie, do you want to jump in?
Well, I'll be short because I feel like I spoke a lot, but we do need to redesign the international investment governance system. And we need to find the right place to do it, because depending on where it is, the chances of it being truly, in advancement of sustainable development can vary depending on the forum. So we need to choose also the right forum to do this. But this has been a great conversation.
Thank you. And I will note to the participants that the work that Nathalie and her institute have done on the moratorium is also linked now to the chat, so you can go there and visit. Brooke, do you want to share a word?
Sure, very quickly. I'll sort of bring this full circle back to all of the issues that Minister Espinosa was talking about at the beginning, talking about all of the different ways we need to affect these changes for sustainable development, and in particular for developing countries. So I just wanted to point out the moratorium to which she referred and signed calls for both, which we were talking about today, which is a permanent restriction on COVID claims, but also moratorium on all claims, simply because countries who are in sovereign debt crises cannot be expected to be able to do all of those other things if they don't have the funds to do so. And so this is really, I think, an important policy question as to where we are going to be allocating finances and funds of countries in the coming years.
All right. So unfortunately, we have run out of time. I would be very happy to keep going, but it's a time to stop. I think that we've covered a wide range of policy proposals and legal options for states to think about the work ahead. And also, I think, as Mr. Espinosa pointed out, the important agenda of working together with public officials to try to make this happen. And so I think that there's a lot of ground to cover, but I'm very encouraged by this conversation. And I thank all of you for joining us, for sharing the time to talk about your ideas and proposals. And I also want to thank the team at CAROLA, the Executive Director, Lelia Mooney, and our fellow Mario Osorio, as well as Cara Dobbs from the Centers and Institutes team, and Cal Bernardos from the AV support team. They've all been incredibly helpful. And finally, thank you to all the attendees. We will be having another session of our first module on investment law this Thursday at 11 a.m. Washington time, talking about career paths. So don't miss that. Thank you all and have a good week.